Welcome to KingCast.net Mortgage Movies. Today we're featuring the Jurist versus the Hillbilly. This is the Jurist before you, the seasoned Jurist of the Year, Alan Wilner. This is the Hillbilly, Mickey Norman, the hand-picked Hillbilly. The seasoned Jurist reasoned with a full committee that Emergency Rule 14-2071 should be in place for these reasons. However, the Hillbilly contradicted that, and he made certain to slam a homeowner who raised the issue of improper documentation, even though Maryland has a history of that. Let's take a look, shall we?
Admissible in this case.
Because on page 4 of the mortgage banker's statements in the Florida Supreme Court, they state, I quote, "Many firms file loss note counts because the physical document was deliberately eliminated to avoid confusion immediately upon its conversion to electronic files. See State Street Bank and Trust Company versus Lord, 51-7-2-790 Florida 4th CA." I didn't have knowledge of this when Mr. Dorr was in the stand. I would have presented this to him and said, "Mr. Dorr, how can you explain that you claim to have a note, claim to be the original from M&T Bank, when the Florida mortgage bankers in the Supreme Court stated all physical notes are destroyed. They're not only destroyed, they're deliberately eliminated. So how can a physical, original, wet ink signature, authenticated note, which, mind you, there were 2 different copies entered into the 08 case and the 10 case, one with endorsement, one without. How can Mr. Dorr state that he has the original with credibility, competence, or liability? It's impossible. The Florida mortgage bankers and Mr. Dorr admitted he has no first-hand knowledge. Only I can authenticate. I'm not going to go back that, but there's substantial contrary evidence that if I don't have it here somewhere in this transcript that says it's not my signature, I think I objected every other way I could have possibly done. Maybe I forgot to say it was my signature. It is not my signature. That note is not authenticated.
Well, that train has left the station. You had ample opportunity in a contested hearing to produce whatever evidence you wanted at the time concerning your signature. Your decision to perhaps not perjure yourself, it's unimportant. Your decision not to do that is your decision. Your document's inadmissible. Next, how much longer will you be in your presentation? I'm not intending to cut you off this message.
Oh, yes, he is. He has put the burden on Mr. Wetzelberger to prove that the signature is not his. That's crazy. Mickey Norman is a plant. He is a corrupt judge doing corrupt things, and at another point in this transcript, he clearly states that the reason for 14-2071 had nothing to do with fraudulent documentation, when in point of fact it does, and that was the central point of the whole thing, as noted by Maryland's Judge of the Year. So who is this clown, and how did he get to be on the case after one of the bank's attorneys served him a courtesy copy of a pleading before he was even assigned to the case? The whole court system is corrupt, and I'm calling him on it.
You talk about the term claim, so why don't you focus it?
Sure. Did you receive, did you file a blank order of possession in this underlying case?
I thought a motion for possession was a proposed order.
Yes. Thank you. And in response to that, did you receive an extrajudicial notice from Todd Wetzelberger to validate that claim with strict proof?
What do you mean by extrajudicial?
Outside of court. I sent it to him private, to Mr. McCantrell. I sent a notice.
So you asked him if he received something you sent to him?
Yes.
Is that what you're asking him?
Correct.
Let's not use flowery words. Let's cut to the chase. Did you receive something from Mr. Wetzelberger?
See, why is he interrupting Mr. Wetzelberger? Mr. Wetzelberger asked him, did you receive something extrajudicially outside of the court proceedings? And then Mickey Norman steps in and says, let's not use flowery language. And he's criticizing everything that Mr. Wetzelberger does. Extrajudicial process is a valid process in these cases. But the plant, Mickey Norman, steps in here on his throne to prove that Mr. Wetzelberger is a vexatious litigant and all kinds of negative things in order to protect the banks, because this judge is corrupt and might as well be paid off. And he's a liar as well, as noted when he says that Rule 14-2071 was not created to address document fraud. This guy should not be on the bench. He's corrupt.
That's the Dock Act. I don't know if you're familiar with this, Counselor. Lorraine Brown was president of DocX. All the foreclosure, most, if not all the foreclosure attorneys across the country use DocX and lender processing services for their foreclosure documents. Notes, releases of mortgages, releases
But what
of
does that have to do with this case? Wasn't there a hearing wherein testimony was taken? You had a right to produce whatever evidence you want. Doesn't that happen? So don't tell me about DocX and don't tell me about the rest of the country. Let's talk about this case, sir, please.
Yes, 3 years ago that happened. If you hear foreclosure cases, the clerk said you hear a lot of foreclosure, you're on the rotation. There's a lot that's happened in 3 years. Mr. Dorr was found in December to have violated multiple rules of professional conduct. He admitted to it, and literally after that hearing in August of 2010, 3 months later, the Daily Record and the Baltimore Sun both reported that when the Rule 14-207.1 was actually granted, like I filed years ago, some error denied to me, when that 14-207.1 show cause hearing was granted, Mr. Dorr was brought into court and he admitted he could not authenticate documents. 18 notaries lost their notary commissions. That all happened after that hearing. So this is, I think Mr. Dorr actually...
So to make sure I understand your argument,
yes.
So you're saying subsequent events
Yes.
should impact what, in terms of Mr. Dorr, impact the entire foreclosure procedure concerning your residence. Is that what you're saying?
Absolutely, because it shows the propensity for fraud. They covered up the fraud for a long time. Then it became obvious that he was involved in fraudulent practices. And not one, but 2 judges admonished him on it. Now this judge, this hand-picked Mickey Norman clown, is covering it all up.
Your procedure concerning your residence. Is that what you're saying?
Yes.
Okay.
Yes, I didn't have prior notice of that. When I examined Mr. Dorr that day, I had no prior notice he was going to testify as a witness. Had no prior notice he was going to bring a note. And I understand they don't have to give me notice. So I had to wing it that day. I wasn't prepared to examine Mr. Dorr under oath. I just kind of had to wing it. And
Wasn't all that documentation contained in the request to docket?
Copies.
Bob?
Copies.
Well, but so you knew about the documents, correct or not?
Correct.
Okay.
And
Go ahead.
I'm just saying, at that hearing that day, this is 3 years, it was 3 years ago.
Listen to him. Go ahead, because I'm getting ready to burn you anyway. This guy's a total cracker.
That day, this is 3 years, it was 3 years ago. I had no notice Mr. Dorr was going to show up to testify. I had no idea Mr. Cantrell was going to be here. So I'm hoping, I'll try to agree if I can examine Mr. Cantrell a few questions. But I didn't know that day Mr. Dorr was going to show up with a note. I objected to the note. I understand this better than probably anybody in this room. Fraudulent documents are filed every day, and I stated it on the record that day. I objected to that note. Mr. Dorr can't authenticate it. I'm not going to say it again, but I don't understand and it doesn't make sense to me. He cannot authenticate that document. Only a credible, competent, reliable witness can authenticate admissible evidence.
Well, let's go back for a moment.
Yep.
You had an opportunity to challenge that document.
I did.
And the court found against you. And I repeat myself, the Wetzelbergers put on absolutely no evidence that the signatures were not authentic or not authorized. You admit that is an accurate statement.
That's an accurate
So
statement.
should we go back and relitigate all this?
Yes. Because it's not their burden to put on evidence that the signatures are not theirs. That's ridiculous. The burden of authenticity is on the moving party. It's just ridiculous.
Go back and relitigate all this when you were given an opportunity to challenge the authenticity of the signatures and you did not?
I did challenge the authenticity. It's right in the transcript testimony. I objected literally to admit.
Did you get on the stand and say that?
It's right in the transcript testimony. I objected literally to admit.
Did you get on the stand and say, that's not my signature?
I was under oath the whole time.
Did you get on the stand and say, that's not my signature? It's a fairly simple question, Mr. Wetzelberger. Did you do that?
I did not get on the stand because I was sworn in by Judge Nagel at the beginning of the hearing.
Did you say that?
Yes, if you read the transcript testimony.
Then explain to me why you agree with the assertion that or not authentic or not authorized.
You see, and he keeps coming back to that, which again misplaces the burden. This judge was a complete ringer. And I can't find the part where he said about the real purpose of 14-2071, but it's in here. I'll find it.